Well, good evening. Welcome to another of those very odd things when the people speaking don't really know if there's anybody out there. Although we've had a lot of interest in this evening's discussion, and I'm sure those of you who are joining are going to find it really stimulating and thought-provoking. Welcome to another Europe is Possible. This is our Brexit Spotlight session. And today we've got 60 minutes on the Human Rights Act. And I cannot think of two better people to talk about the Human Rights Act with. We have got not just one, but two incredibly smart, very well informed, and perhaps most importantly, principled and passionate about human rights speakers with us this evening. They will both resist the title of expert, but they do bring a huge amount of expertise, both academic and practical. We're going to have about 30 minutes of conversation with Francesca and Natalie, who I'll introduce a bit more in a moment. And then an opportunity for questions from the audience. If you want to put your questions in the Q&A function down at the bottom of the screen, that would be great. If you accidentally put it in the chat, don't worry, because Luke will probably spot it in there as well. If we don't get around to all of your questions, I'm sure we can persuade our eminent speakers to give us some answers after the event as well. If you're not a member of Another Europe is Possible, you are very, very welcome to this event all the same, but please do join us. Yeah, we're amongst friends. We're here because we care. No question is daft, so please do feel free to ask whatever you want to of Francesca and Natalie. So Professor Francesca Klug, I will give her a title just once, is a visiting professor at LSE Human Rights. But the reason we've asked her to speak with us this evening is because she actually supported the Labour government in devising a model for incorporating the European Convention on Human Rights into domestic law. And then, because she'd not sufficiently demonstrated what a glutton for punishment she was, she continued to become one of the architects of the Human Rights Act. We've also got Dr. Natalie Sadaka with us, who is a lecturer now in law at the University of Exeter, whose research focuses on human rights and employment law. But before moving to academia, Natalie worked in legal practice for 9 years using the Human Rights Act to pursue claims against the police and public authorities. So we're bringing a really excellent mixture of academic, practical and political insight to today's discussion. So thank you both, Francesca and Natalie, for joining us. We are going to have a chat, and I want to make it as conversational and relaxed as we can manage on a theme as serious as this. And the theme of our discussion this evening is the Human Rights Act at risk? And I suppose even I know the basic answer to that, which is yes. But before we talk more about why, I'd like us really to take a step back into what is it and why does it matter? And so before we really start the conversation, Francesca, you've agreed, and thank you very much for this, that for those of us less expert than you, like me, you're actually just going to talk us through a bit what this thing is and how basically does it work. So we'll have some introductory 5 or 6 minutes from Francesca on that, and then we'll have a bit more of a chat. So welcome again to you all, and over to you, Francesca.
Thanks very much, Laura, and thanks very much for inviting me to speak today and to meet you all. Yes, what is the Human Rights Act? Why was it brought into law in the 1990s? Well, it's a good question, actually, because usually major constitutional change follows revolutions or struggles against imperial rule, doesn't it? That the new Labour government were persuaded to introduce a Bill of Rights in peacetime, as it were, is unusual. So, to cut a very long story short, and I'm afraid we won't be doing any of the juicy bits tonight, introducing a Bill of Rights based on the rights in the European Convention on Human Rights, or ECHR, was initially a John Smith commitment, which, after his tragic death, Tony Blair kept faith with for various reasons, which we could explore later if people are interested. Both leaders were responding to a campaign which took off in the late 1980s, spearheaded by the pressure group Charter 88, to reinvigorate our democracy. Calls for a Bill of Rights went alongside demands for PR, freedom of information, and devolution. Why? Well, in a word, or rather 2 words, Margaret Thatcher. Her government was in power for what seemed a very long time, despite never winning an election with a majority of the popular vote, and yet proceeded to restrict sacrosanct principles like freedom to protest, free speech, the right to silence if accused of a crime, British nationality at birth, etc., etc. And we discovered there was nothing anyone could do about any of this besides wait for another election to come round, which could be won again on a minority vote. Ring a bell? So it was as much a systems thing as a party thing, in truth. The weakness and failure of our famously uncodified constitution to confer almost any accountability, let alone change, between elections was an issue the Tories also highlighted back when Labour was in power in the 1970s, with Lord Hailsham's famous description of our democracy as an elective dictatorship. At that time, a number of senior Tories even called for a Bill of Rights, wait for it, based on the European Convention on Human Rights. Why? Chiefly because we were already signed up to it since 1953. A treaty inspired by the highly progressive, actually, post-war Universal Declaration of Human Rights, far more progressive than the ECHR, in fact, but supported by Churchill, wasn't quite so toxic for the Tories then, even with the word Europe in it, although it was the Attlee government which ratified the ECHR. By the time New Labour were in power in 1997, there were also a couple of high-profile cases where the courts lamented that they couldn't apply the ECHR directly here in the UK because it was not part of our law. One was the case of Smith, challenging the shocking ban on LGBT men and women serving in the armed forces that you'll remember the government announced a retrospective inquiry into after all these years a few weeks ago. What they didn't say is this ban provided one of those watershed moments that brought home what it was like to live in a democracy with no Bill of Rights, with no means for minorities to challenge decisions, policies, or the law driven by popular sentiment or the tabloids or what we call majority rule. Then, in a very different kind of case, there was Gordon Kaye, the star of the then popular TV comedy Allo, Allo, which I must say I never watched and didn't like when I saw snippets of it. But he was shocked to discover that British citizens had no right to privacy whatsoever after a photographer and journalist rocked up at his hospital bed unannounced to splash his poorly image over the pages of the Sunday Sport. Lord Bingham, the judge who was forced to deny him his futile claim to privacy, lamented the failure of both the common law and statutes to provide any kind of remedy. So with most of the rights derived from the ECHR, Labour called their Bill of Rights the Human Rights Act. There are different names for Bills of Rights around the world, and the Human Rights Act seemed a good name to us, giving a strong signal of universalism. But in a way, it was a classic New Labour triangulation. They thought a Bill of Rights might sound a bit radical, whilst the Human Rights Act sounded like a tidying up exercise, apple pie and motherhood, presented almost as an act of patriotism by bringing rights home we already had, but could only claim through a long and expensive journey to the European Court of Human Rights in Strasbourg. But on the tried and tested formula that if it looks like a duck and sounds like a duck, it is a duck, a Bill of Rights is what the Human Rights Act is. And this was sometimes openly acknowledged by Jack Straw, the then Home Secretary. It has, most importantly, the 2 standard features that characterize all Bills of Rights around the world. First, the Human Rights Act applies to everyone in or living under the control of UK law, regardless of nationality, past misdemeanors, or any other characteristic. everyone, which is the most important word in human rights law, from young people with autism detained in mental hospitals to asylum seekers facing deportation, has the right to challenge violations of their human rights by public bodies under the Human Rights Act, both inside and outside the courtroom. The second feature which makes the Human Rights a Bill of Rights is that it is a higher law, which under Section 3, don't worry, I'm not going to go all technical on you, but under Section 3, all other laws and policies must comply with the Human Rights Act wherever possible. In fact, the government has to make a statement to that effect every time a new Act of Parliament is introduced. Through this vital mechanism, a first outside EU law for the UK, but standard in bills of rights around the world, the courts have, for example, reinterpreted our legislation to recognise same-sex couples as next of kin for tenancy inheritance purposes and as a nearest relative under the Mental Health Act. These were not provisions in any other law. It was the Human Rights Act which reinterpreted our legislation to give gay couples these fundamental rights long before the Equality Act. Now, despite what the government says, our courts are perfectly free to develop their own interpretation of the European Court of Human Rights and are not bound and gagged by the European Court of Human Rights. But unlike American or German Supreme Courts, our higher courts are not permitted to strike down full acts of Parliament under the Human Rights Act. Under Section 4, judges can only declare acts in breach of our human rights, and it's up to Parliament to decide how and whether to respond. Why is this the case? Well, this might surprise some of you, but it was because New Labour, in fact, the whole Labour Party, from left to right, was almost as opposed to fully overturning the doctrine of parliamentary sovereignty as the government is now. And this was for both good and bad reasons, which we can explore later if you're interested. As a result, some human rights lawyers were nervous that the Human Rights Act would be a damp squib. But in fact, the higher courts have issued 44 declarations of incompatibility since the Human Rights Act came in 2000, leading the government to change the law in nearly every case that was not overturned on appeal. This has included, for example, extending civil partnerships to all couples, ending discrimination in the provision of widows' bereavement allowance, and changing the Housing Act to include dependent migrant children as a marker of priority need, as if it needed an act of Parliament to tell anyone that. Were the human rights a damp squib, of course, it's unlikely the government would be seeking to overhaul it now. So you may be all wondering, why is it that this government is proposing to repeal our Bill of Rights based on the rights in the ECHR in order to introduce a Bill of Rights based on the rights of the ECHR? Hold that thought. We'll come back to it later. Thanks.
It is a bit Kafkaesque when you put it like that. And also listening to you, I mean, I have to say, another of the many things we need to fix is that we need people called Lord Hailsham and Lord Bingham to point out the common sense to us. That was really, really clear. Thank you so much.
Unfortunately, Laura, they're both dead, but never mind.
Yeah. We're relying on their successors now, though, aren't we? Natalie, you probably knew all that. Do you want to give us some insights into the difference this has made in your work? Francesca's already touched upon some issues, but can you tell us about how in real life, you know, when it's not Lords Bingham and Hailsham opining, how this has worked for you and how you've made using the Human Rights Act work for your clients?
Oh yeah, great. Thank you so much for the introduction and for inviting me. And it was great to have that first introduction from Francesca, because I think, you know, it is important to have a sense of how the HRA works to understand what they're, you know, how they're kind of trying to now pick it apart. So I think it's important to say that, you know, the protection from the Human Rights Act covers a huge range of areas. So from the rights of people in care homes, migrants' rights, children, people who've been victims of crime and not had adequate protection, as well as those who've experienced more kind of direct classic violations. So I'm just going to give a snapshot and partly drawing on things that I did in practice, but it's by far, it's not an exhaustive list at all. And I think, in fact, looking at who's here in the audience as well, there would be people who have other examples to give. So one area that human rights claims came into was in relation to freedom of assembly in cases that arose from protests. So some of my examples were like the evictions of the Dale Farm Traveller site and the G20 summit in London. So in those cases, if people are wrongly arrested at protests and so on, they will often have claims under domestic law that predates the Human Rights Act as well, such as false imprisonment if they've been detained, assault if they have been handcuffed and had other force used on them, and then that's turned out to be unlawful. But in addition to this, there was a human rights element because the fact that they've been arrested and stopped from protesting means that the rights to freedom of expression, which is Article 10 of the ECHR, and freedom of assembly have been interfered with. And in some cases, there were also really onerous bail conditions, which we argued were a breach of the right to private and family life, which is Article 8. So with most of those cases, they were settled before they went to a full trial. So there wasn't like a separate hearing that determined, how much would there be for the human rights elements. But it is an important additional dimension to the claims, because it's important to recognise that, pre-HRA, there was not a positive right to freedom of expression or freedom of assembly. You kind of just had what was left after being told what you couldn't do. And human rights, continue be really relevant to defending protest rights. So people might remember the really shocking scenes from March of last year when the vigil held after the death of Sarah Everard was violently attacked by the police, who were deeming it to be unlawful under COVID regulations, and Reclaim These Streets, which was the organisation that had originally wanted to put on an agreed vigil and were threatened to with fines of up to £10,000 each, brought a judicial review claim that relied on the Human Rights Act. That was heard last month. It's awaiting judgment, I believe, at the moment, seeking a declaration that their right to freedom of speech and freedom of assembly were breached by the refusal. So without the HRA, the grounds for bringing that judicial review would be much more limited. And given the government is trying to significantly curtail protest rights through the police crime and sentencing bill, there's even greater need to have that human rights protection, to have that positive human rights protection. So looking at another example, I represented a woman who was held on remand, so awaiting trial. She gave birth while in prison, and she had her baby taken away from her a couple of days after she was born because she was denied a place in the mother and baby unit. And she was Polish, she had quite limited English, and she'd been given very little opportunity to take on board documents and to make her case as to why, while the internal process was going on. And so we challenged this through a judicial review relying on the Human Rights Act as well. And it was accepted that the procedures followed by the prison authorities didn't comply with the procedural elements of Article 8, so the right to private and family life. And had the HRA not been in force, this would have been, I think, much harder, if not impossible, to bring in terms of anything in the domestic court. So then you might have had to go all the way to Strasbourg to challenge that, so to the European Court of Human Rights. And that could have been many years of delay, could have had a really profound impact on later events. Another of my cases was on the right to liberty, Article 5. So a man who'd been detained for quite a long time after the order of a family court judge that was subsequently overturned. And the HRA has also been extremely important in relation to inquests, so the process that happens after certain types of deaths, particularly where there's potential state involvement. And a key example of that is the Hillsborough Disaster. Most people will be familiar, but it took place in 1989, and the original, and it involved kind of police, letting far too many people into a football stadium and a crush, and then really bad mismanagement. And basically the original inquests that were held were extremely narrow, didn't get to the full causes. The families had to fight for years and years to get to the truth. And in 2012, there was an order that Article 2 of the ECHR, the right to life, required new inquests to be held. And finally, in 2014, so 27 years on, the inquest jury ruled that people at Hillsborough were unlawfully killed, and they identified a series of failings by police and ambulance service that contributed to that. Likewise, HRA has been really important in holding the police to account for failing to investigate particular types of crimes properly, and that's something that's really difficult to find a remedy for in our domestic law. So that's included victims of trafficking and modern slavery, using Article 4 ECHR, so the prohibition of slavery and forced labour, and also really important in cases of gender-based violence, so includes sort of famously the failures in properly investigating the so-called black cab rapist John Warboys, which were found to be in violation of obligations under Article 3, which is the prohibition on torture, inhuman or degrading treatment. And it is an area where the HRA fills a significant gap in pre-existing law that just doesn't provide avenues for that type of claim. We've also seen that in the case of Joanna Michael, who was murdered by her former partner after she'd reported threats and the police had failed to act on them properly. In 2015, the Supreme Court ruled that her family was barred from making a claim in negligence, which would be the equivalent kind of domestic law route. Whereas the parts of her claim that were under the Human Rights Act relating to the right to life were allowed to proceed. So without the Human Rights Act, again, no remedy. Now, of course, I'm not going to go into this in detail, but there are also limits under the HRA, including significant practical ones. So legal aid for civil claims is which includes claims under the HRA, is subject to a means test, so only available to those of very limited financial means, and a merits test. So not all claims will be funded by any means. And there are many other reasons it's far from perfect. The same goes for the ECHR, but it has allowed many minoritized and working class people, among others, to bring claims to vindicate their rights that otherwise wouldn't have been possible.
And I think in your final comments there, I'm starting to understand perhaps a bit of the answer to the next question, which is why is the government opening this up for discussion? Presumably it's not because it wants to enhance further the rights of migrant communities, for example. That would seem to be at odds with its general public policy approach. Migrants' rights, the right to protest, upholding the rights of people in their complaints against the state. Is it all just about winding all of that back? What's motivating this government consultation? Can either of you, perhaps we'll start with Francesca, can you genuinely find anything positive in what the government is trying to do? Are we too cynical to start from the assumption that
most people, I'm afraid, when it comes to this, are not cynical enough? They hear the phrase Bill of Rights, they hear that we're still going to be signed up to the European Convention on Human Rights, which, by the way, the government had pretty much no choice but to continue to do, because with the Brexit withdrawal treaty, the trade agreement between the UK and the EU required us to remain within the European Convention on Human Rights, or else the EU will withdraw cooperation on data protection, on crime. And so pretty well, they knew they had to stay within the European Convention on Human Rights. And this whole exercise is to answer the question, how do we stay within it, but make it more or less toothless and useless? And I think to answer that, I know that Natalie is going to go on and talk about some of the details in the consultation paper. So I'll take you at your words and just try and look at some of the politics behind it as I see it. And forgive me if this is an answer steeped in cynicism, but it's based on many, many years of experience with all this. That is that since Cameron, the human rights has basically been the go-to, along with health and safety legislation, in the culture wars, which started long before this government. Although for obvious reasons, health and safety is a little bit of a more tricky target these days. Promising to repeal the Human Rights Act and even withdraw from the ECHR, a particular favourite of Theresa May's, by the way, without actually doing any of that, was a handy recycled substitute for Brexit for many years, wasn't it? And a means of differentiating the Tories from a meddling Labour state, which kept insisting that you have all these human rights which you can claim, which isn't just about freedom, but which requires a state to do things, for example, like investigate crimes. So why now, when Brexit is allegedly already done, is the government seriously now moving to overhaul, for which read seriously maul the Human Rights Act? Well, I think there's three reasons. Firstly, frankly, to throw a repeatedly resuscitated dead cat as an early intervention in Operation Save Big Dog. Never have cats and dogs been such happy companions, in my view. Why do I say it? Well, when you think about it, the government's consultation paper was published just after the first details of Partygate were spilling out in mid-December. An independent review into the Human Rights Act, chaired by Sir Peter Gross, had been commissioned by the previous Justice Secretary when the government came into power, and they had reported that they published the government its report at the same time as this consultation paper, but proceeded to completely ignore what's in the independent review because it doesn't work as a dead cat. It's not critical of the Human Rights Act. So the Tories and tabloids have been so successful over the years in fusing the Human Rights Act, the European Convention, and the EU in the public mind that the Johnson cavalry is now, in my view, aiming to fuel up their base by claiming to take back control from the last remnants of the European superstate by promising to overhaul the Human Rights Act and free our courts from European Court of Human Rights diktats, which, as I've said, they're already free from. Second, it's a personal project of Dominic Raab. No question about that, who was rewarded with the Justice Secretary brief by the PM for that very reason when he was demoted as Foreign Secretary, and we all remember why he was demoted as Foreign Secretary. We shouldn't underestimate, in my view, the role of ideology on the right. I think we sometimes do that. In 2008, Raab was the author of The Assault on Liberty, What Went Wrong with Rights, a book which is a plea to rescue ancient British common law freedoms from the clutch of liberty-reducing continental rights, for which read the ECHR. As I'm sure Natalie will elaborate, the reason why someone like Raab sees the ECHR as liberty-reducing is because under human rights law, there are positive obligations on public bodies to protect our rights, not just refrain from abusing them, i.e. there's a right to, not just a freedom from, and this can cost money, and is one of the provisions that Raab is gunning for in his so-called overhaul. And on this basis, if these positive obligations are removed, the reopening of the Hillsborough inquest would not have happened, and the scale of the war boys attacks on women that Natalie just talked about would have remained under-investigated. And third and finally, of course, all the other government measures which threaten to fall foul of the Human Rights Act, such as the Police Act, the Nationality and Borders Bill, and the Human Rights ID Bill, they're the reason why the Human Rights Act's demise is no surprise. For as long as it's on the statute book unamended, the Human Rights Act remains a serious threat to the rest of the government's Diminish Executive Accountability project.
Well, that was cheerful.
Totally uncynical. I hope you noted.
Yes, that's a cold shower of an answer, isn't it? Although I've absolutely no reason to doubt. Natalie, does that tally with your understanding of why the government is doing this? Are points that Francesca's made that you want to sort of elaborate on?
Yeah, I mean, it will be a pretty similar analysis, but I mean, I would say, so if you did a non-cynical reading, read it in good faith without much kind of background in seeing how this has been a long-term project, the best you could say is it's about taking us to a conservative minimalist view of human rights. So no positive obligations, no duties on the state, and very much kind of, you know, there's lots of reference to, we want to go back to the rights we originally signed up to in 1950, not the way they've been expanded. There's lots of attacks on, there's a doctrine in the European Court of Human Rights, which is the living instrument, which is nothing very complicated. It's just the idea that rights move with the times. So at the time, you know, 1950, when the ECHR was agreed, LGBT plus rights was not a thing. Like, that was not something society had got its head around yet. So the living instrument has been crucial for example, that development. So we see attacks on that. So at best, it would be like a conservative and minimalist reading. But when you read it more carefully, it is worse than that. So it is more about being formally able to say that we remain committed to the ECHR, but kind of weakening the ways that it's enforced and incorporated into our domestic law, you know, to the point that it would be quite possibly almost meaningless, and in particular about limiting its application to unpopular groups such as those convicted of crimes who aren't UK citizens, which they call foreign national offenders, irregular migrants, prisoners, so-called gang members. And so weakening the universalist nature of human rights, which is really at the core of what they're supposed to be about. And as Francesca has explained, this goes back to, it's very much a project of Dominic Raab, but also goes back to David Cameron. David Cameron famously had said after, so there'd been a judgment against the UK about against the blanket ban on prisoner voting, convicted prisoners voting, and David Cameron said, we don't want to act on this because the idea of prisoners having the right to vote makes me feel physically sick. So we've seen it, you know, again and again in different manifesto pledges. But what is concerning about this moment is that they found a way. Previously, they would make the commitment, they would say, we're going to have a new Bill of Rights, and they'd come up against, well, which right would you actually get rid of? And they could never answer that. And now they've kind of found a way around that, potentially by saying, no, we're keeping all the rights. We're just, you know, making it so that essentially their protection is going to be hugely weakened. And I think it's very much, again, echoing Francesca's point, so I won't kind of go back into all the names of the bills. But if we see all those other bills, it is part of a broader agenda of shifting power to the executive and reducing ways for ordinary people to challenge their agenda and actions. So, you know, and yes, it's at consultation stage at the moment, so there is a chance to respond. But when you look at it, many of the consultation questions are phrased in a way that assumes the correctness of an agenda and is just about how best to do it. So, yeah, it is a very concerning moment that we're at.
So you've touched on there, Natalie, in fact, on a question that I've just seen that James Newell has asked. So I'm just going to ask you both, before we open up more widely to the audience, perhaps to give us some more examples of the specific changes that the government wants to make, but also, if either of you know, can you say anything more about the timetable for this consultation, and when, you know, when we might expect this to actually, I mean, they've got an 80-seat majority, how long it actually takes for them to destroy this thing, but also, yes, if you want to highlight any of the specific changes that are being proposed. I don't know which one of you wants to go first. Francesca?
Well, I think is it the 8th of March, Natalie? It's something like that. You can very easily locate the consultation document and enjoy going through these questions that they ask. It's, you know, just Google, you know, government review of the Human Rights Act. It'll come up, and you can see there's a sort of multiple choice survey at the end. I would personally deal with it with great caution, in the sense that they're trying to trap you into agreeing there was all these things wrong with the Human Rights Act and give you alternatives about how to address them, rather than stand back and say, actually, I don't see the problem. And the independent review that your government commission came up with this result. There is no fundamental problem and hardly any changes. So there would be a way of, you know, very successfully, I think, and very cleverly answering these questions by constantly denying that the question is legitimate. But in terms of what's in there, look, Natalie's just given you, I think, a very good overview. But I want to give a piece of advice, if I may, Laura, and that is, at this point, I think most people should throw away their legal textbooks and philosophy treatises on human rights and grab their Orwell, Alice Through the Looking Glass and Little Red Riding Hood instead, if they want to understand what this is all about. I mean, in a nutshell, both of the characteristics of a Bill of Rights I mentioned earlier are either challenged or obliterated by these proposals, depending which options that they give are followed. It's Orwellian, first of all, to call this measure a Bill of Rights, when there will be no interpretive clause comparable to what I described as being in Section 3, the one we have now, which makes the Human Rights Act a higher law. And that's the whole point of Bills of Rights. Either it will be repealed altogether, this section, or considerably weakened. Second, as Natalie has explained, there's no universal entitlement anymore to the rights and remedies in this so-called Bill of Rights. And this is where we enter the topsy-turvy world of Alice Through the Looking Glass. Once you select, Laura, whole categories of people, and you will know this well, to whom rights or remedies don't apply, or not to the same degree, it's nonsense to claim the ECHR or indeed the philosophy of modern post-war human rights are being respected. And Natalie gave examples of this. There's to be a permission stage, making it harder for individuals to enforce their rights, especially for anyone who already experiences barriers accessing justice. There's no other area of law where it's necessary to reach a threshold as high as they're suggesting, which is significant disadvantage to bring a claim. Additionally, damages may be reduced in part or in full on account of the applicant's previous conduct, not just in relation to the rights they claimed, but say they've been, protesters in the past and been jailed for it under the new police bill. That, for all we know, based on what they're saying here, their damages may be reduced if they want to claim any human rights. If that's followed through, no human rights remedies for bad people is as an egregious dent in the philosophy of modern international human rights as it gets. And finally, as Natalie has also suggested, there's a clear intention to stop the Human Rights Act preventing deportations on family life grounds. This would minimally apply to foreign national offenders, but the consultation document suggests it could go much wider. So to sum up, many features that makes the Human Rights Act a Bill of Rights will be removed or reduced in the name of introducing one. The sum total of the proposals is to make fewer rights accessible to fewer people in fewer circumstances. Yet all of this is presented as reinforcing our freedoms. And this is where you need to dust down your old copy of Red Riding Hood. For were we not warned, Laura, from our childhood stories, that what at first glance looks like a kind grandma can turn out to be a dangerous wolf?
Yeah. And on that point, unless Natalie, there's anything you want to add, I think I might bring in a question from someone in our audience.
I mean, I was going to add, I don't know, it depends how much detail. I haven't kind of gone into anything yet about the detail of it. So it depends how much detail you want, or whether you would rather kind of go into questions and have a broader discussion, and maybe I can follow those points up there.
Yeah, well, look, we've got a great question, I think, from Clive, which I read from Clive Baldwin, who works for Human Rights Watch and is sitting out there somewhere in the ether. There he is. He's now appeared on screen with a little yellow hand. So I'm going to ask Clive to unmute himself and speak, and then we'll come back to you though, obviously, Natalie. Clive, hi.
Hi, I guess you can hear me. Thanks for the great presentation, although very depressing to be hearing this after, I think in my first year as a trainee lawyer, I was working on the Human Rights Act. But as I work internationally, just wanted to say that internationally, human rights is much broader than the ECHR. It's economic, social, cultural rights, it's workers' rights, it's equality rights, although we lost some of the protection of those latter two when we had the hard Brexit and left the EU. But do you think there's any chance for the panelists that at least some of the parties in, say, England or the UK, especially the Labour Party, could take up these issues as human rights and widen the discussion, not keep it the narrow one that the Tories have, the way that the SNP government in Scotland seems to be doing?
Great question. Which of you wants to go first on that?
Provided Natalie answers every other question, I don't mind quickly answering. I think a lot of NGOs and human rights activists have hoped for years now, every time the government, starting with Cameron, mentioned the phrase Bill of Rights, that this would be an opportunity to do, as you say, Clive, and insert other international human rights standards into a new Bill of Rights, which obviously, you know, what's not to like. Unfortunately, this has come out just as many of us feared and warned, which is a bill of less rights. And the only additional rights that have even floated are the right to jury trial, which but according to the law. Well, the whole point of a Bill of Rights is it's not according to the law. You can challenge the law. And if it's according to the law, then we've already got a right to jury trial. In other words, it's not an expansive right. And the other one was in responding to Meghan Markle's successful claim of privacy, offering the press up our privacy rights, basically in the context of the tabloid business model, saying that that free expression will be you know, promoted at the expense of privacy. Now, we could discuss that for hours, but I would like to put to you that actually there is no problem in the balance that is being set by the Human Rights Act between those two rights, and that is really red meat for the press in order for the Tories to have a better press at a very difficult time, which is why I talked about this being part of, say, Big Dog. I think the Labour Party, on the other hand, I would like to think, Clive, could be persuaded finally to take seriously many of us in the human rights world who've been trying to talk to them about expanding the European Convention on Human Rights in the Human Rights Act to include, not taking away from it, but building on it to include economic, social and cultural rights. It's a big discussion. And there's been people on the left who've always opposed that because they feel that this should be about a democratic process and shouldn't end up as being something that's decided in the courts. I'm on the side of expanding the Bill of Rights. I understand the argument against it. But let's be honest, we can keep talking to the Labour Party about that, but we have to be very, very clear. Every time we imply that a Bill of Rights is something that's going to lead to something more progressive, we're walking straight into the Red Riding Hood trap that I feel that I suggested has been set for us. We have to be very clear that a Bill of Rights can be regressive as well as progressive, and this is a very regressive one.
I think just to add as well that, I mean, I think it would be great if the Labour Party would take this up. I don't really know whether they will or not, but I think one thing which isn't specifically mentioned in the consultation, but certainly the ECHR and the HRA are primarily about civil and political rights, and that's a limitation of them. But there has been the development within the ECHR, and to a lesser extent in its counterpart in Latin America, which is much more progressive in a lot of ways, of what's called an integrated approach, where to some extent economic and social rights and labour rights are read in to those civil and political rights. So we've seen, for example, the development of rights relating to strike action and collective bargaining that weren't explicitly in the ECHR, but by that progressive development. Now, the consultation doesn't specifically attack that, but it does attack a sort of parallel and not identical, but in some ways related development of positive obligations. And, you know, it's clearly opposed to. So I mean, I think it would be great. There's lots of different steps that could be taken to have better protection of of economic and social rights. So there's a parallel instrument to the ECHR called the European Social Charter. The UK's ratified that, but it hasn't ratified its revised version, which has slightly stronger mechanisms. Similarly, there's at international level, we have the International Covenant on Economic, Social and Cultural Rights. We've ratified that, but not the kind of procedure that allows people to make complaints about individual complaints about violations. So yeah, there's there's lots of different ways, but I think that it's at some points there's maybe been speculation that a Bill of Rights might bring these additional rights in, and that is absolutely crystal clear that is not on the agenda here. So I think it would be it's probably not that helpful to think of it as part of a Bill of Rights, just because of the atmosphere that we're in and the atmosphere that this project has been about kind of attacking rights rather than expanding them.
So you're both in a way saying that whilst you in principle would support the expansion, clearly you've both been very clear about that, as a tactic for responding to this consultation, that's it's probably not the way to go.
Well, it wouldn't allow you to say that in response. That's
Right.
not how the consultation is framed. The consultation will be things like, it's been agreed, you know, we all like, you know, how do we achieve our aim of stopping foreign national offenders using human rights? It's not like it's not phrased in an open way, like what should be changed about human rights. Of course, you can try and get those in somehow, sneak them in. But you won't be, if you're doing that, you won't be replying really directly to their questions, because you're not really given that opportunity.
So it's a Ryanair kind of drop down menu in which you can complain about the food, you can complain about the air hostess, and you can complain about your chair, but you're not allowed to point out that the plane didn't take off or it took you to the wrong place when it did.
I think you could quite easily with it. I agree with everything Natalie said, but I think you could quite easily question in many of the in many of your answers whether this is a Bill of Rights at all, whether there are any characteristics left that would make this a Bill of Rights, especially if certain of the options are taken. So I think that could be a recurring theme, and then say, well, you know, given you're asking me this question, I think A or B, but I can't see how this makes it a Bill of Rights.
And do we know how many people, by the way, as we're talking about consultation, those of you who've got a question, please do put them in either the chat or the Q&A. Do we know how much take-up there's been of this consultation? Has there been a lot of engagement? One of the people in the chat I noticed said there's so much going on at the moment with all of the bills which you referred to before, in fact, Francesca, that it almost feels as if this is slipping under the radar. That is clearly also part of the Tory intent. Has there been a big response to this consultation?
I mean, I don't think either of us can possibly know at this point, because it hasn't been closed yet, and it's not, as far as I know, public. I think that the hope is that we're all being blinded by the science of the law, if you like, that it's that people are meant to not understand it, are meant to just assume that it's quite a benign proposal because the convention is not being withdrawn from, the Human Rights Act is not being overturned, and that therefore most people will be apathetic about it. It is, if I may say so, a fundamental error to think that energy should be put into the individual pieces of legislation that are being introduced and not into opposing the end of the one piece of umbrella law we have, that is the Human Rights Act, that can challenge all these new pieces of legislation, which is the point I was making, and is one of the reasons why I believe they're acting on this now, having held the possibility of doing so for years. They're now moving forward because really they have to, because they're going to be, tied up in knots if they keep the Human Rights Act as it is and try and do what they're doing with the policing bill and with the Nationality and Borders Bill and with the voter ID bill. All of them are very seriously challengeable under the Human Rights Act. Now, it's not that you wouldn't be able to challenge them under this new Bill of Less Rights, but you'd be far less likely to get anywhere. First of all. Secondly, it depends who you are, because as we said, certain categories of people will now be in a situation where it's very, very hard to claim their rights under this new Bill of Rights. And thirdly, and this is something neither of us have mentioned yet, I think we shouldn't underestimate the freezing effect this is going to have on our courts. Just the very existence of this bill. I think Natalie's agreeing with me. I mean, we often talk about, how measures freeze, freedom of speech. They don't, whether you are personally tied up in it or not, you mustn't say this, and so you stop uttering words. Well, it's very similar with the courts. It's very naive to think that they live in some sort of bubble and don't take any notice of the signals that come from government about what they can and can't do. In fact, we're already seeing it in the way that the courts are interpreting the Human Rights Act much more conservatively on the whole than they used to. This is a great big red light to them. Keep off our laws, keep off our policies, go back into your box. At least we're freeing you from that pesky European Court of Human Rights. That is basically the message that will be going out to the courts. And therefore, I think it will be far less likely that you will see the overturning of the draconian single pieces of legislation that's being introduced as we speak.
Yeah, and I think like it's so to give one of the examples of kind of the specific mechanisms they're proposing and to say how this overlaps with a broader agenda. So as Francesca mentioned right at the beginning, so one thing that's kind of distinctive about our system, even with the HRA, is that the courts can't strike down primary legislation. However, as it stands, they can, if it violates human rights, they can strike down secondary legislation, so i.e. legislation that is just a minister has been given power and gone away and made it. But one of the proposals is to actually remove that. So the courts would no longer be able to strike down secondary legislation. And they're really, really shielding the executive. And at the same time, we see a big increase in the use of that type of secondary legislation. So in the Nationality and Borders Bill, for example, Clause 59 delegates the power to executive to make regulations to define who is or isn't a victim of modern slavery or human trafficking. So if that was done in a way contrary to obligations under Article 4, the prohibition on slavery and forced labour, it couldn't be then struck down. It would have to go through this process of being declared incompatible and then having to go back to be re-legislated again. So it in that way, very much kind of part of this broader agenda.
So continue.
I was only going to say, because Natalie brought up, modern slavery. And it's a good illustration of how the Human Rights Act has transformed the legal landscape. I mean, people who are just a little bit younger than me won't really remember what life was like before the Human Rights Act. It really was very, very different. You didn't have positive rights. Your rights were what was left after the law told you what you mustn't do. The silence of the law told you that you could do something, but if the government of the day decided to legislate, you couldn't do it anymore, and there was no way of challenging that. Then you have something like the Human Rights Act that not only gives you a positive right that you can claim inside and outside the courtroom. And by the way, there's been massive changes without ever going to court through the Human Rights Act. Most recently in the pandemic, elderly people and their relatives challenging quite draconian visiting measures, perhaps more draconian than they needed to be. And every time they threatened to take a case under the Human Rights Act, that their right to family life was being impaired by the fact that people in care homes were suddenly being denied the right of company of their loved ones, the government kept changing the guidelines because they didn't want the court case. And there's so many examples like this. But just going back to modern slavery, because the Human Rights Act requires the government of the day to protect our rights under the Human Rights Act, the very thing that Dominic Raab wrote against, it meant when there was a vacuum in that we didn't protect people from modern slavery, our courts declared that a breach of the Human Rights Act, and the government was forced to introduce legislation to protect people against modern slavery. There was no such law before the Human Rights Act, and there probably wouldn't still be now. This is what a Bill of Rights does. Eviscerating it, which is what the government is intending to do, will over time transform the landscape in this country. And those of us who have longer memories know what I'm talking about.
So you have both made a powerful case for why we need to hang on to this thing. In our final 5 minutes, picking up on questions raised by, and apologies because I haven't got my spectacles on, Vanessa, June, James, Graham, all of them in slightly different ways are saying, okay, so what can we do? And who is mobilizing in defense of this? I don't know which of you wants to go first with the answer to this $1 million question, including, for example, who is calling out the bias in the consultation, which is the question that James has raised, which seems to be particularly sort of egregious. Natalie, organisations mobilising.
Yeah, I mean, it's down to all of us to do this and to work this out. But I mean, yeah, Liberty is a kind of key one, of course, because they are such a key human rights organisation, and they actually have quite a helpful guide to help with responses that helps cut through some of the jargon and things that might not be obvious. There's been some good materials on it on the UK Human Rights blog and the Institute the IRR, which I think is Institute of Racial Relations. But I think, I mean, as Francesca sort of mentioned a bit earlier, we can respond to it in a way that calls out the I don't, you know, it shouldn't be boycotted as a consultation, because that's just going to, then they'll just say, well, we had no opposition to it. So it needs to be responded to, but in a way that, you know, with particular questions just says, you know, we reject the premise of this question and this is why. And there is one, I think maybe the final question in the consultation about how it would affect the impacts it would have. So even, you know, even if you're not responding necessarily to everything, that's a really key one to call out some of the very, very negative impacts that it would have on Black people, on people of color, on LGBT plus people, on refugees, so also on women, so all sorts of minority groups that would suffer from this, I think would be important. But we also need to, you know, be ready to campaign more broadly, because the consultation is flawed, you know, in the way it's phrased, and, you know, even to the extent we can respond, it doesn't mean that they'll necessarily listen to that.
Francesca, which railing are you tying yourself to?
I think, you know, Liberty has a very, very useful document which is called Tips for Responding to the Consultation. So get in touch with them, and they do demystify it to an extent, but as Natalie said, they also help you see where it is, you know, you might personally be affected. The British Institute of Human Rights had an event that I was frog marched to be involved in as well recently, and I think that's going up on the website, and that was an event mainly for other NGOs, and it's quite useful perhaps to look at their website. I think that's where it'll be, to see the podcast of that or the recording of that. I think Natalie said the most important thing, though, which is that all of us have a responsibility to do something about it. I think that this is relying on apathy, like with everything else that is happening at the moment. It's relying on apathy. It's very, very serious. Most countries in the world, you do not have governments who take away their bills of rights or make them weaker without an absolute outcry. They are relying on our passivity. That is the only reason why they can do this. And if we complain enough, it won't happen. There's the House of Lords, as we know. This is what our democracies come down to, a bunch of unelected people. But there will be people in there with huge expertise on this and who will care. And we need to lobby them. We need to talk about it. It really, really matters. If they can get away with this, they can get away with almost anything. This is comparable to what Russia has done in the way that they've stayed within the European Convention on Human Rights, but basically make a mockery of it. And that's what this is doing. There was a big fuss when the government said they were going to breach international law when it came to business. Let's have the same fuss when they say they're going to breach international law when it comes to our fundamental civil and political rights.
Well, Another Europe, of course, agrees with you, and we are going to be launching an online tool to help submit, help people in their submission of a loud no to the consultation and its terms of reference. So we are going to be sending that out, and pluralists to our core, I am sure, will also be happy to share the propaganda from Liberty and from the British Institute of Human Rights. Those of you out there who've joined us this evening, if you have expertise, tools, websites, and so on that you'd like to share, dump it in the chat by all means now, but also let us know in the Another Europe is Possible office, and we'll be happy to tell people about that. Thank you very much to you both for having joined us this evening. I think it's been a mixture of slightly depressing, but very informative. We are lucky to have people like you in our midst. And yes, Clive Sheldon, I think we can form a working group to protest. And if you'd like to help us get going, then let us know. Please get in touch with the office. Thank you ever so much to everyone who joined us this evening. Thank you to our brilliant panelists. We want to keep this Brexit Spotlight series going. So if there are issues that you're particularly interested in, let us know. Thank you, Clive Baldwin, for putting in the chat the Liberty Know Your Human Rights Act. We will make that public to people as well. Final thank you to Luke for getting us organised. Most of all, to all of you as you commute back to your living room, bedroom, kitchen. Go safely. And Natalie and Francesca, thank you to you both, and all power to your human rights elbows in coming weeks in resisting this. And have a nice evening.
Thanks for your great sharing.
Yeah, thank you very much. Bye.